Good afternoon, everybody. I see everyone's joining rapidly. Wonderful to see the incredible response and looking forward to sharing with you and engaging with you. We'll just wait until our numbers sort of steady. We're up to 99, 100, and we are expecting quite a few more, but I think seeing as it's 2 o'clock, we should begin and people will join in due course. So thank you so much for joining. My name is Felicity Stedman. I'm a mediator and have been a mediator for the last 36 years, qualified and accredited in 1989. And I am a founding director of Conflict Dynamics. Still work very closely with Conflict Dynamics, but I also mediate in the UK and train mediators for CEDA, the Centre for Effective Dispute Resolution. So we have a wonderful nexus between conflict dynamics and CEDA and a really good international perspective on mediation training and on mediation practice. I am joined today by two of our very close colleagues, very close to conflict dynamics, Samantha Pumapi and Hendrik Kotze, who are both very experienced mediators and who are both lead faculty members. That means they train on our mediator skills training course, commercial mediator skills training course. They also coach and assess on the course, and I'll talk a bit more about that at the very end. So you're hearing today from three people who have a great deal of experience as mediators. We have different backgrounds. Hendrik and Samantha will tell you that they come from a legal background. I don't. I come from a different background. And perhaps that's something that that might strike you during our conversation today, that mediation is much less about the law and much more about helping people resolve problems to achieve commercial outcomes that work for them in their businesses and in their relationships. So let me go to you, Samantha, and ask you to introduce yourself.
Good afternoon, everyone. As Felicity has said, my name is Samantha Pumapi. I am a qualified barrister and mediator and arbitrator. I practice some of the time as a barrister in the UK. I mediate all my time in South Africa, and I have been doing so for about 11 years, and I've been a barrister for coming up to 20 years. My expertise is really in relation to commercial disputes. I do some labour disputes, but yet mostly commercial. Thank you.
Thank you, Sam. Hendrik.
Yes, good afternoon, everyone. As Felicity has indicated, I started my career in law. I first worked at the Legal Resources Centre and then practiced at the bar in Cape Town. I qualified as a mediator in 2007, and my mediation practice mostly is in the field of commercial mediation, though I also do some organizational mediation work. I am also a member of the ADR Advisory Committee to the South African Law Reform Commission that's busy crafting the mediation bill for South Africa.
Thank you. And Hendrik might tell you a little more later about the recent steps that he has been very closely involved in terms of professionalizing the field. So you might be wondering where Tefo Raditpole is, because we did advertise that it was going to be me and Tefo. Sadly, Tefo had a knee operation last week, and he found himself on Monday this morning unable to join us. And we, of course, wish him a speedy recovery. And we have two very able alternative mediators with us today. In fact, perhaps a richer discussion than just Tefo and myself. So a bit of a background to the topic. I think, as we all know, mediation is on the lips of disputing parties throughout the country. not only because of the introduction of High Court Rule 41A, but also more particularly in Gauteng, with the introduction of the Mediation Directive and Protocol, which requires that parties mediate before they are given a date to progress their matter through the courts. And we find in conflict dynamics that when people contact us about mediation and want to finding out about what it all involves, and they realize they have to set up a mediation, they have a lot of misconceptions about what mediation is all about. And they misunderstand what it means. They don't know what it means. And so they have a lot of fears and concerns as well about what it might mean and what they're in for and what their clients are in for. So we identified 10 possible myths about mediation that I will share with you in a moment. And we're going to talk to those myths and really have a conversation about those myths. And if you have questions or you think there are other myths, please add them in the chat, and we will watch the chat and either weave our responses into our conversation or pick them all up at the end. So just to give you a sense of what those myths are that we're going to discuss so that you know whether your fear and concern is going to be addressed or not, let me show you what we've identified. So first of all, that mediation is just like arbitration or litigation. Why can't we just go straight from declaration of dispute to arbitration and litigation? Because mediation is pretty much the same, and why waste our time on mediation? Then we'll have a look at the role of the mediator and the misconception that the mediator decides the outcome or acts as a judge or gives advice or makes recommendations or proposals. Then, of course, people sometimes say our matter is not suitable for mediation. And I think in the revised protocol, there is a slight change where there is the question of the parties and the judge perhaps contemplating whether a matter is suitable for mediation. So we want to talk about suitability. And there is the idea that mediation is only really suitable for small and simple disputes and not for complex ones. And then, although there is now compulsion in the mediation system, in the justice system, particularly in Gauteng, some people feel that by suggesting mediation, they're showing a sense of weakness or guilt or fear about litigation. So how can you mediate without sending a signal, the risk of sending a signal that you have doubts about your case? Why would you? Mediation discussions, this is all about confidentiality. Mediation discussions can be used against me in court. So what are the protections for parties in mediation from the point of view of confidentiality and without prejudice? Mediation, if mediation fails, it's a waste of time and money because of course there are no guarantees. You might be sort of strongly encouraged to mediate, but you don't have to stay there. And so if we have to go through that hoop and it doesn't work, we've been forced there and we're going to just be spending time and money. Why would we do that? Mediators give legal advice, so that's a little bit along the lines of the mediator deciding the outcome. So legal advice, I've said already that not all mediators are lawyers. So what about legal advice, recommendations, and proposals? Then the fear that when you come to mediation, you're always going to have to give in, and that you're going to have to compromise in a case where you believe you have a strong case. So what does it really mean? This outcome in mediation? is it a horrible compromise, or is there a better outcome that can be achieved in mediation, perhaps an outcome that no one would have thought of, and that the mediation process manages to elicit? And then some practicalities, like how does it work? And do I have to sit in the other room with a party who I don't like, haven't seen for months or years, don't want to have anything to do with, just want my money from? Do I have to sit in the same room as them? And where will this take place? Face to face, online, neutral venue, their offices, my offices? So some answers there. And then mediation agreements are not legally binding. And mediation agreement here, we mean the outcome. So people fear that they'll come to mediation, spend a whole day mediating, reach agreement, but that the outcome is not binding and that the matter might still proceed to court and that the party will not comply, the other party will not comply with what's been agreed. So we'll talk about that. Okay, and we're absolutely encouraging comments and questions and additional myths. Before we do that, it would be helpful to know who is here today, so we can pitch our presentation to whether it's mediators we're talking to or to legal practitioners. And so we're going to give you a short poll. We've got 150 people present, which is fantastic. Let's hear who you are, your background, if you can indicate with our poll. We are doing many RAF mediations in terms of the directive and protocol. So we've got medical doctors there because doctors are increasingly interested in mediating and very well aware of the value of settling disputes early, whether they be disputes with in the RAF context or disputes between doctors or doctors and hospitals, doctors and patients. We've got a point there about employee-related disputes, so that might be that you're dealing with those sorts of disputes as a lawyer, or dealing with those sorts of disputes as an HR or ER practitioner. A few more responses. So we've got 72% of the group having voted. Let's have a look at what we have in our group. Okay, so hopefully everybody can see the results. They're being shared. And yeah, so mostly attorneys and advocates. You might also, as an attorney or an advocate, be a mediator. So we didn't restrict it to a single answer. And many advocates and attorneys are mediators. And we every course we run, there's a preponderance of legal practitioners. We've got 2 medical doctors, 5 academics, a couple of HR managers. We've got 2 judges, psychologists, social workers. There's a lot of mediation. There's a lot of mediation in the workplace. So that doesn't is not really captured by the current sort of focus on Rule 41A and civil and commercial mediation. But it's interesting that the HR, ER, social workers are here as well, because mediation can be used very effectively within organizations or within professional associations before they've taken on a legal dimension. Okay, wonderful. Well, I'm pleased, frankly, that there are attorneys and advocates here, because those are the people who contact us about mediation, and they have the questions in the first instance. So let's see if we can dispel some of the myths and address your fears and concerns. We're going to conduct this conversation in a very conversational way. And so I'm going to lead us through the 10 myths, and Sam and Hendrik will respond in each case. So very informal. We are recording, But we can't see you and you won't appear on the screen in any recording, so no need to worry about that. So let's start with the first one. Mediation is just like arbitration and litigation. So this really goes to what is mediation? A definition, perhaps.
Okay, thank you, Felicity. Yes, so mediation essentially is an enhanced negotiation process. The parties often, before they resorted to litigation, tried through direct negotiation to resolve the dispute, and often that fails, and then the next step that they take is to go and consult the lawyers, and often that leads to the start of a litigation process. Mediation often happens within the context of a litigation process because the parties feel, or as is in the case in Gauteng now, the parties are required to again try through a negotiation to reach a settlement in the matter. Mediation is a different form of negotiation because mediation involves the participation and the management of the negotiation process by an independent person, the mediator, who has been trained and has specific skills of how to enhance the negotiation process. The structure of the negotiation process is also different in that the parties are often not in the same room when the negotiation takes place, and the mediator is able to get almost a bird's eye view of all the matters in dispute, and because of that is able to facilitate settlement agreements more successfully than the parties can directly. Very important to understand that the mediator has no decision-making authority. The mediator cannot make a decision about the outcome of the matter. The only enforceable outcome that comes out of a mediation is a settlement agreement between the parties. In other words, the parties need to reach consensus about an outcome, and then once that's reduced to writing and signed, that becomes binding. The mediator can make no finding, so in that sense, the role of the mediator is fundamentally different from the role of an arbitrator or the role of a judge. Arbitrators and judges have a specific role to adjudicate the outcome of the dispute. The arbitrator's award is final and binding based on the contract between the parties, and the judge's ruling is final, subject to the processes of appeal due to the authority of the court. Just to summarize then again, the mediator enhances the negotiation process and assists the parties to reach a settled consensual agreement.
Okay. So Sam, Hendricks made the point about the mediator does not decide the outcome. So how does the mediator work in enhancing the negotiation process? Maybe you could just tell us a little bit about how the parties arrive at the outcome. What's going on in the rooms? How do they arrive at the outcome, the parties?
Thanks, Felicity. So, as Hendrik said, mediators are not judges. We're not here to make a decision in relation to these matters. We are here to facilitate, and what we say is to facilitate a conversation between the parties so that they can communicate with each other or through the mediator, and we manage the process and help the parties think about their options, think about the strengths and weaknesses of their case. We ask them to, we do a bit of reality testing to see how it would go in court. For example, if you were to go to court, what would happen? But it really is for the parties themselves to come up with their own solutions to the problems. It is not the mediator's position to say, well, this is the outcome that I think it should be, and follow me. The parties can reach a settlement themselves with our help.
Right.
So, in terms of I'm sorry. Go ahead.
No, go ahead.
In terms of qualifications, as you already mentioned, Felicity is not a lawyer, whereas we have two lawyers here, myself and Hendrik. often mediators have varying skills. So not only lawyers, because we're not here to give legal advice. We are trained professionals, so you can be trained by Conflict Dynamics or a number of other organisations, but you have to go through the whole process. It's not just a quick fix and read a book. There is a whole process that goes through, so you know that the people who come as mediators are trained and have the skills to be able to facilitate your cases. Sorry, Felicity.
Forgive me, I've got a cold and I'm sounding very hoarse. But somebody once said to me that mediation is like turbocharged negotiation, which relates to what Hendrik said about enhanced negotiation. So, and you've talked about the training of mediators. So, what is it what do people who are mediators need to learn? Because often we hear lawyers in particular saying, I negotiate all the time. I negotiate settlement agreements with the lawyer on the other side. Why do we need a mediator? And why can't I just be called a mediator? Because I know how to do this. So what is it that is different about us as mediators?
I think Kennedy's put some of what I was going to say. You coach the mediator, you coach the parties, you show them, you walk them through the process of negotiation. You sit in the middle and you speak to one party, you unpack the skills that not necessarily a lawyer or a doctor would have generally. We are taught those particular skills over a prolonged period, and we coach them to come to a settlement. It is not just being a lawyer. And in fact, I often say that I come with a different hat depending on what I'm doing. So when I'm a barrister, I have my wig on. I don't really, but I would have my wig on. And when I'm a mediator, it's a totally different hat. It's a totally different way of presenting and listening. I hope that's answered the question, Felicity.
Yeah. So we train in the art of negotiation. So there's a deep understanding of negotiation. We train in communication skills, effective active listening, etc. And then in the mediation process, which is a different kind of process to negotiation in terms of the format. We meet with parties in private rooms, we meet them together, and as Hendrik said, we have a bird's eye view as we move backwards and forwards of how this is working and how best to bring them towards and coach them towards an outcome that works for both parties. Now, Hendrik, sometimes people say, well, that's all very well if you've got a neighborhood dispute or an employment dispute, CCMA and so on. But my dispute is really complicated, involves millions of rands and maybe even multi-party. So what do you say about the suitability of mediation for bigger cases?
Thank you, Felicity. Mediation certainly is very suitable for resolving small, medium, and large and very large disputes. The focus in the mediation is on trying to find a settlement based on the parties' commercial interests. And the reality is that the bigger the dispute, the higher the value of the value of the dispute, the bigger those commercial interests are. And in a sense, there is even more incentive for parties in those very large disputes to try and find a commercial settlement, because the impact of those big disputes on their businesses, on their lives, is just that much bigger. Yeah. So in that sense, you often find that it is those bigger disputes that almost more readily come to mediation, because in a sense, the risks for the parties and the impact of ongoing litigation is just so substantial.
Right.
So I think we all in our personal practice have had experience of literally billions of rands of disputes involving multiple parties, often multinational corporations, all being involved in a single dispute, and those matters are normally very successful and very often result in settlements. Similarly, in multi-stakeholder disputes where you don't just have two or three or four parties, but a whole range of stakeholders that need to give input on a particular matter of dispute. Mediation is an ideal process. The litigation process is just so complex to involve that many number of disputants, whereas and within a mediation context, that can be accommodated very easily. I've personally been involved in a mediation around the terms of agreement about the management of a World Heritage Site that involved 17 different stakeholders, and there was a team of mediators involved, and they were able to reach a very sustainable agreement that included the needs and the interests of all those participants. So certainly the size of the dispute is not an indication of whether or not the matter is suitable for mediation.
Yeah. People often think of a mediation as a one-day event. So we're going to give it a try. If it doesn't settle, that's the end of it. How flexible is the mediation process in those more complex disputes or multi-party disputes?
It's very flexible. What you would often find is that if it is such a substantial matter and it does involve a range of stakeholders, the mediator would often do a lot more preparatory work in meeting with each one of the parties, each one of the stakeholders, in preparation for a more formal mediation session. So that the mediator starts to build rapport, starts to understand the needs and the interests of each one of those participants prior to putting everybody together in one big mediation conference. And sometimes the mediation just carries on in that almost shuttle diplomacy basis, and you never have a big coming together of everybody. The process is completely flexible. Mediators are often trained in how to deal with those more complex kinds of dispute and have very good skills about managing such processes in a way that makes everybody feel involved and yet is able to give momentum and purpose to the whole process.
Yeah, yeah. And I think what you're suggesting there, amongst other things, is the mediator is not just a mediator for the day. The mediator is a process designer. And in those more complex matters where actually it's more facilitation skills and process design skills, mediators are well suited to helping the parties identify all the stakeholders that could be involved, and then set up preparation meetings, information gathering meetings, and then move them into a problem-solving process.
Absolutely. That's a very accurate summary.
Yeah,
And
yeah.
if I could just add one more point on this, Felicity, is that people often say, my case is so strong, I don't see any need as to why I should go to mediation. And I think it's just important to understand that the fact that your case is strong and you're likely to get a successful outcome in the litigation, it doesn't mean that commercially that's the best route for you to go.
Yeah.
We all know what the delays in the courts are. We all know how a final outcome can be delayed through appeals processes, etc. So mediation, even though you have a strong case, gives you an opportunity to get a good commercial outcome quickly.
Yes, yes. So in the mediation process, we're not just talking about merits, legal strengths, legal risks. We're saying to the commercial parties, so, how can you solve this commercial problem in your interests, your current interests, and perhaps even in your future interests? The potential for ongoing business, the risk of lost opportunity, etc.
Exactly.
Okay. Great. There was a hand up. I just wanted to say that we'll pick up any questions towards the end, unless we address them as we go along. but we won't respond to hands at this stage. So just pop your points, your questions or comments in either the Q&A section or in the chat section. Okay, so let's go to mediation is a sign of weakness and a sign that you are not sure about succeeding in court. And so you've decided to try and compromise the matter. Samantha, how do you react to that?
Well, Hendrik's already touched on it. It is not a sign of weakness, we would say, and it can't be held against you in court because you went to mediation or because you said, I'd like to mediate. In fact, it shows that you're strategically thinking about your case. When one looks at cases in South Africa, when you can get a date on the roll in a couple of years, it's very similar in England. You're having cases in a year being listed. So one may have to think about it commercially and says, actually, I'm not going to worry about how strong my case is. What I'm going to worry about is the impact this could have on my business, for example. The fact it's going to take a year to get to any resolution, that there could be an appeals process, the time and the cost of litigation. And when I say time, I'm talking about the impact on your business, managers being out in order to prepare this case, meeting with lawyers, etc. So often when one looks at whether you should mediate or not, it's not about how strong your case is or how weak it is. It's about wanting to come to a resolution, probably quicker than if you go to court. And we know, as all the lawyers in the room will know, and I'm sure some of you others that are in the room also will know, Rule 41A requires the parties to consider and provide reasons if they refuse. So it's now more of a why have you not gone, as opposed to why are you going to mediation if you have a strong case?
Yeah. Yeah, so let's say it doesn't settle, and there's been a sort of a very full discussion in the mediation. Perhaps documents have been shared in the mediation with the other party, with the mediator. Hendrik, can those discussions or those disclosures be used against a party in court? So sometimes people worry that if they come to mediation, the other party will use it as a sort of fishing expedition to gather information about the case that they'll have to face down the line. So how do we prevent that from happening, and how can we reassure people up front that that won't happen as mediators? How do we do that?
So the basis of any mediation is an agreement to mediate between the parties. And the terms of that agreement, at least if parties use a proper standard template, would always include a provision that provides that the mediation is confidential and that anything that is said during the mediation, any offers that are made, any admissions that are made, any discussions in the mediation are confidential and cannot be used in any other context. A second principle that is always in those agreements to mediate is the principle that the mediation is without prejudice. So the mediation does not affect the parties' existing legal rights, and if the mediation fails, all those rights remain in place and parties can carry on and enforce their rights. There are, of course, limitations to these, for instance, whistleblower obligations that every one of us has to report certain crimes that we become aware of. But outside of those exceptions, these two principles are absolutely the foundation on which mediation works and which creates a safe environment in which the parties can explore offers, can make suggestions about how the case can be settled, and knowing that those offers cannot later come back to bite them. They're confidential and they cannot be used in any other context. Currently, these principles are contractual principles, so the parties have that protection by reason of the fact that they've signed an agreement But once the mediation bill becomes legislation, hopefully in the not too distant future, there will also be a legislative basis that gives the same protection for mediation.
Right, right. So really key is the agreement to mediate, which provides the contractual protection. We have in conflict dynamics a model agreement to mediate, and that's available on our website. And sometimes the parties negotiate slightly different terms. It's the mediator will not start the mediation unless that agreement has been signed, and the mediator signs it as well, because the mediator is subject to those same provisions around confidentiality and without faith. I mean, without prejudice. Now, what if the mediation is not going so well, and when the mediator does their mediator report, they answer that question about good faith, bad faith, by saying, well, they have to reflect on this. They have to think, was the conduct in the mediation meaningful and in good faith? And let's say they say no. Um, how can the court then inquire into what went on in the mediation um, when they come to perhaps considering costs?
Sorry, I missed that last question, Felicity.
Oh, okay. So I'm
Yeah,
just saying that in the mediator report that this is
yeah.
in terms
Oh,
this is
yes.
in
Yeah,
terms of
yeah,
of mandatory mediation. Obviously, but there's no mediator
yeah,
report in private mediation, but in mandatory mediation, the
yeah,
mediator has to report on good
yeah.
faith, bad faith, which is not so much about
Yes,
the content, but about the conduct of the
correct.
parties.
Yeah,
Could this be exposed?
yeah. Felicity, it does raise possibly a gray area because in terms of the protocol in Gauteng, the mediator has that obligation to report to court. Um, I think the best approach currently, and that's based on discussion with senior colleagues, is that the mediator's confidentiality obligations to the parties must be balanced with the need of the court to understand where parties truly acted in bad faith. And to that extent, uh, our view is that a mediator would only disclose to the court where there was conduct that very clearly can only be considered to be bad faith. Conduct such as not arriving at an organized mediation meeting, conduct such as not disclosing the documentation that to the mediator that's needed for preparation, or attending but refusing to say anything. The fact that a party does not move from their position in the mediation, I think in our considered view, the mediator does not know enough to say that simply because a party did not move from their position, they were acting in bad faith. They may have very good reasons why they didn't move from their position, and the mediator may just not understand why they held so firmly to their position. So in that sense, good practice. I think the kind of the broad consensus of opinion is that good practice would require the mediator to not form opinions just based on the fact that a party didn't make concessions and wasn't willing to move.
Yeah.
But there are other clear examples of actions that just derails the process where that reporting duty can and should be given effect to.
Yeah. I think that's an important point. People sometimes fear that by coming to mediation, they're going to be forced
Mm,
to compromise
mm,
and and give up something. And we're not that's not what mediation is about. It's coming with an open mind and a willingness to have the conversation, consider other ways of looking at the problem, uh, different options to resolve the problem. If at the end of the mediation they choose not to, they're not compelled to agree. Yeah. Sam, do you want to add on that, or go on to the point about, well, what if the mediation fails? Has it been a waste of time and money?
Well, very often parties are concerned whether they've already spent a lot of money on litigation, they've got their cases prepared, and they're very worried about spending more money on a mediation that may not settle. But what you do get if you go to mediation very often is, even if you don't settle, you clarify the issues. So very often you can narrow down what they are actually arguing about, because very often parties are throwing everything in and not getting very far, whereas at least the mediator can communicate to each other, and then they see the strengths or weaknesses of certain aspects of their case, and they say, well, actually, we're not going to pursue that. We often, the parties are able to narrow the scope of their dispute, which inevitably will save costs because there'll be less issues to argue when you get to court. We spoke earlier, Felicity, but in relation to RAF matters, this has been seen, and in fact, one of my most recent cases where I did an RAF matter, they were able to settle liability and the majority of quantum, but general damages remained. So one could say you didn't settle because not all issues were resolved. But on the other hand, the only issue now to go to trial is the issue of general damages, which obviously will cut down the amount of costs, probably cut down the time limit and cut down the amount of legal costs that the parties will have to pay. So I would say it generally isn't a waste of time or money. There's some sort of enlightenment. You find out things that you probably would never have known before.
Yeah, yeah. And we don't, as mediators, tempting as it is, we don't measure our success on it settled or it didn't on the day, because as Sam's saying, we can unlock quite a lot in a mediation, either by narrowing the issues or getting people thinking about things in different ways. And so settled shortly thereafter is another metric we look at and follow up on. And the very vast majority of disputes either settle on the day or settle shortly thereafter. The statistics are in the 80s and 90s. Hendrik?
Yeah. Felicity, I think one should also not underestimate the psychological impact of the mediation on the parties. It often is a very real and a very formal moment where they get to confront each other and actually have an engagement about the dispute. And even though they don't always settle the dispute, often the fact of having had that confrontation and having had that opportunity to almost, it's not quite the day in the court, but there is that element of having faced the other side and being able to tell them how I feel. That often allows them to make more rational decisions even after the mediation has failed. And as you say, we often see cases settling after a mediation has terminated unsuccessfully, but the parties then still manage to come to settlement. And I think that is because psychologically, at least, they've been able to move on and make more rational decisions.
Yeah.
Mm.
Yeah.
Mm.
Okay. There was a question that has suddenly, yes, Aaron has raised a question, Hendrik, in relation to what you said a moment ago about the report. And his question is, are you saying that the mediator is focusing more on process than on substance when assessing good or bad faith?
Yeah. In essence, I think what I'm saying is the mediator can much easier deduct bad faith participation on process issues, people not pitching, people not supplying information. So those are observable, objective facts, and it's relatively easy for the mediator to report on that. I think what I am saying is that a mediator needs to be very careful about making a judgment call to say that in terms of substance, a party acted in bad faith simply because they did not make certain concessions or didn't move far enough in the mediator's view.
Yeah.
That remains the party's prerogative about what is in their own interest and where a good settlement lies for them. And the moment that we ask the mediator to decide where a good settlement ought to be, we're asking the mediator essentially to make a judgment call about the dispute. And that's fundamentally opposed to the role of a mediator.
Yeah, yeah, yeah. Um, yeah, absolutely. Now, yes, the other aspect of the report is for the mediator to comment on whether the party had a mandate or not. And maybe
Yeah,
that's something slightly different. So, if someone comes along and they say, I'm just here to listen, I have no authority, then obviously that's a problem.
yeah,
And that's the sort of thing a mediator might comment on. But the
absolutely.
quality of the mandate is not for the mediator to comment on.
The extent of the mandate, yes.
Yeah,
Yeah.
yeah,
It is whether there is a mandate, it is whether the decision maker potentially is available on the day of the mediation, if not present in the room, but at least available to be consulted with if there is an agreed outcome that needs confirmation. Um, what is sometimes true is that the parties explicitly agree up front that the final decision needs to be taken elsewhere, and this is often the case with big corporates or with government departments. But at least then that should be known up front and not be discovered during the mediation when a settlement is on the table. That would certainly be bad faith.
yeah, yeah. Okay.
Mm.
And then just leading on from that, you've made the point about the mediator's role switching if they were to give a view on the substance of the negotiation and uh, a view on merits or anything like that. So, can the parties ask the mediator, especially if they have a legal background as mediator, what they think the settlement should be or the strength of their case? Can the parties maybe say, we'd like you to make the proposal or recommend a settlement? What expectations can parties have in those regards?
Felicity, the current arrangement in most standard mediation agreements in the commercial space, at least, is that the mediator is supposed to be a facilitative mediator. And the Gauteng protocol also requires mediators to play a facilitative role. That means that contractually, the role of the mediator is focused specifically on being the facilitator, and that explicitly excludes the giving of any advice to any of the parties. So the mediator would be stepping outside of the terms of their mandate if they were to give an opinion to the parties on any aspect relating to the law or the facts. That it's not for the mediator to give that advice. I think those of us who've practiced law have often kind of seen judges mediating cases where they say to the one party, I think your case has got some problems on this and that. Go and think about it and make them an offer. That's not what facilitative mediators do. Facilitative mediators assist the parties in understanding their commercial realities and on making decisions based on what is in their best commercial interests to get to a settlement. And it's for the parties to decide if something is in their interest or not. What
Yeah,
is really useful in those mediation processes is having the lawyer there as an advisor to the parties, because the lawyers play an absolutely critical role during the mediation process in advising the parties about the legal side of things. And it's often in the reality of the mediation where parties are starting to understand what their commercial realities is that kind of voice of reason that the lawyer is able to provide helps them to make difficult decisions and reach settlements which really are in their interest at the end of the day.
yeah, yeah. Um, okay. To what
Sorry,
extent?
Felicity.
Yeah, yeah,
Sorry, can I just add one more point? And that is to say that there are areas of practice where a specific industry have indicated and understood that a more advisory role from the mediator is required and makes more commercial sense in that specific industry. And the built industry is a good example of that. You'll find that most mediation agreements in the built industry specifically stipulates that a mediator will play an advisory role. And if that is the case, then yes, then the mediator can express opinion. They will still try and facilitate an agreement, but at some point they will put on the advisory role and maybe nudge parties in a specific direction based on what they have seen.
And that's very specifically covered in the rules or the agreement, the terms of reference that the mediator is working in terms of, and both parties would have signed up to that. We have a question from Caroline about ARB-Med and Med-ARB. And yeah, those hybrid processes can be very useful. Again, they need to be agreed upfront and formally. So I've done ARB-Meds. I can't say I've done any Med-ARBs. There are risks with Med-ARB, and we see in the CCMA how they do have that, but they've separated the mediator person from the arbitrator person, because you want, as a mediator, to work with people in private meetings and talk to them confidentially. And if you do that and you become the arbitrator, you might be making your decision as an arbitrator based on information that parties have not had an opportunity to challenge and contest. So there is some flexibility about the role of the mediator. It needs to be agreed and ideally become part of the contract. So Samantha, the thinking about what happens in a mediation and whether people often fear that their client is going to come into mediation and be put under pressure to settle in a matter that would otherwise be resolved or decided in their favor if they went to court. And you've made a point about settlement versus waiting the time and the costs, etc., to go through court. But what can you say about the quality of the outcome of a mediation in terms of, is it just a compromise under pressure where people give in, or what does it look like?
Well, the benefit of mediation is that the parties are able to come up with their own solutions. So it's not as if the mediator sits there and says, this is what you're going to accept. So you won't be ever bullied into something or told this is what you have to do. And I can say the beauty of it is that they can design the solution themselves, the parties can. So certain things that the lawyer the judge wouldn't order, for example, he wouldn't order that they must continue working together, the parties must continue working together on certain projects. It's not within the rules. But in the mediation, the parties are able to specifically design the solution and sign up to that, to say, we will work together on the next project, and the profits will be split in any which way they determine between themselves. So it's more creative, it's tailored. And I would say the agreements tend to be stuck to because the parties themselves have tailored the agreement to suit them. In a very much way that the court cannot do that. So it's not simply a compromise. And often people say, well, you're just going to meet in the middle or 50-50. That's not how it works, because 50-50 might not be where it is suitable to both parties. It might be a slightly different or creative solution, which includes looking at different ways of working together in the future, looking at an apology. There are many different ways which the parties will have, which will be able to tailor into their agreements, and they will sign up to themselves. So it definitely is not the mediator pushing parties to give in or to settle. Yes, it is a very long day, or it can be a very long process. but it does require the parties' engagement, and it is for them at the end to draft and settle to agree what they will put in their agreement.
Yeah. Could you perhaps also comment on something we really emphasize in our mediator training and negotiation skills training, and that is positions versus interests, and how, what sort of interests is a mediator exploring that a judge can't explore within within the framework of the law that results in a more creative outcome.
Well, very often when you're discussing with the parties in the separate rooms, you will find out what is feeding into their positions. So it might be, I need to settle this because I'm very worried about the media, or I'm very worried about my reputation, or I need to settle this urgently because I need this money to go into another business deal. Those are certain things that the judge would never find out about. And therefore they can say, well, I'm going to settle this on this basis because I need X, Y, and Z. So that's the advantage of going into those separate rooms, unpacking and finding out what the actual needs are of the parties, as opposed to a judge who is going to make a decision and not know what the real needs of the parties are.
Yeah, and I think we sometimes discover that they need different things. So for one party, cash flow is a big issue, so it's important to get money soon. But for the other party, who has the money, certainty is more important. So different needs can be addressed. Okay, excuse me for a moment. Turning now to some of the practicalities and the fear that lawyers have for their clients. How can I put my client through this traumatic experience of having them sit in the same room? And Nicolette de Wit has made the point in the chat about the plaintiff being traumatized by being in the same room as the doctor. Now, the mediator is process manager. I said earlier, designer of the mediation or facilitation process. And that's more broad, that's in a broad sense, but also in a very specific sense. So the mediator will meet with the parties beforehand, before the mediation, in preparation meetings, usually online like this. And if an attorney is worried about their client facing the doctor in a joint meeting, well, then there'll be a conversation about that, and the mediator will be made aware of it, and the mediator will need to think about whether to have a joint meeting at the beginning of the mediation. It's not compulsory to have a joint meeting. It may be that the parties don't actually meet one another at all during the mediation. They're in separate rooms. It may be that the only people who meet one another are the attorneys. That the mediator bring the attorneys together with the clients remaining in their private rooms if they don't want to actually see the other side. So they are not forced into a face-to-face situation where there might be high degrees of anxiety or the potential for a confrontation. Of course, you can also have mediation online. So you don't actually have to be in the same venue as the other party. And you have online your breakout rooms, and the parties might not see one another at all. And you might wonder, well, how can a settlement be achieved if people aren't talking to one another? But that's where the mediator comes in. The mediator is talking to one side and getting permission to convey information to the other side, backwards and forwards. So their understanding is enhanced. They have a better sense of what's important to the other side and to themselves. And then the mediator is moving backwards and forwards with offers and proposals and helping them move towards an agreement. So it's a flexible process. And the mediator, while being the process manager, will also not force the parties to do anything. but get permission at each stage. I'd like to do this. Are you comfortable with it? Let's do, how much time do you need to prepare before coming into a joint meeting, etc., etc. I know Sam and Hendrik, you've both teach on our course. I wonder if you would like to say anything about that and just the use of what we recommend in terms to our trainees about the flexibility of meetings and the different formats.
Yeah. Felicity, I think the thing that we stress in training is that the mediator needs to ensure that the mediation is a safe space for the participants. And the mediator is in charge of process. The mediation agreement very specifically stipulates that the mediator makes process decisions. The parties are responsible for decisions on the content matter of the dispute. So really, the mediator has a mandate to make the right decisions that are that care for the safety of the parties. And if one party has a fear of being in the room with the other party, then the mediator can make those decisions. I do see a note in the comments about a party refusing to participate in the mediation unless the parties were forced to be together in the same space. That does sound to me like a party wanting to force a process decision on the mediation. I think for me, that would be a case where that party is actually acting in a mala fide way that effectively prevents the mediation from carrying on. So in the example, I mean, given the limited facts that we've seen in the comment, I think that would be one example where I would say the mediator is being prevented from making the correct process decisions to have an effective and safe mediation process. And as a result of that party's standpoint, the mediation has failed. And I would report that to the court in that context.
Yeah, yeah. Sam, any comment on this, particularly from practice?
Just in relation to, one would have to always be attuned to how the parties are presenting, because maybe at the beginning there's no issue being raised, but then when you're in the mediation, you become aware that, for example, somebody's scared or fearful, and then you would need to separate, and that's the basis upon which the mediation can work, because it is a flexible process and it's one that can be tailored to the party's needs.
Yeah, yeah. Okay, so our last myth, before we start integrating some of the questions and comments, is about the outcome of the mediation agreement not being legally binding. And there was a point raised in our chat or in the Q&A about whether a mediation agreement can be made an order of court. So, Hendrik, maybe you can just describe for us what happens at the end of a mediation in terms of drafting, creating a contract, and the bindingness of that contract and how to really make it enforceable.
Yeah. So if the parties reach an in-principle agreement in the mediation process, then that in-principle agreement needs to be recorded in writing, and it needs to be signed by the parties before there is a binding outcome. So just an oral agreement in the mediation context is not binding. It has to have the step of being recorded in writing and being signed by the parties. Now, all the lawyers in the room will understand the power of contract. If parties have signed an agreement, then that agreement regulates the legal position between the parties. So in that sense, the moment that there is a settlement agreement, it changes the legal position of the parties, and the legal position is now, with relation to the dispute, is now as set out in the settlement agreement. So in that sense, that outcome is binding on the parties. and if it's within the context of litigation that settlement is arranged, is arrived at, there will inevitably a provision to say that one or both parties can apply to the court to have the settlement agreement made an order of court, even if it happens outside of the context of litigation. The parties can still approach the court to enforce the terms of that agreement. That agreement now regulates the position between the parties. And to the question in the comments, parties cannot appeal the outcome of a settlement agreement. The settlement agreement is not a judicial ruling. It's not an award by an arbitrator. It's an outcome that they have freely and voluntarily, through consensus, agreed to. And the fact that they have buyer's remorse afterwards is unfortunate for them. They are bound by the agreement that they have signed.
Yeah, yeah, yeah. And that's another good reason to have legal representatives in the
Absolutely.
mediation. You know,
Absolutely.
lawyers sometimes fear that mediation is going to do them out of business. Well, there's a really important role for mediators, for lawyers in mediation, and one of them is to ensure that a proper contract is arrived at. And for the non-lawyers, what would you say, Sam, are the features of an enforceable contract?
Sorry, I missed the question. I'm so sorry for listening.
Okay. For the non-lawyers in the room, well, no, let me ask a different question. And that is, let's say you're in a mediation and the parties are not represented and they come to an agreement. How would you, as mediator, assist them put together an agreement that is going to be sustainable?
Well, ordinarily, I would, because it's important for us not to then become the lawyer, I would try to get the parties to speak to anybody they know as a lawyer and help them draft the agreement. It's important that we now don't take responsibility for the agreement. In the event that they're unable to, one could usually, if they're not represented, I suspect it would be a pretty straightforward. I agree to pay someone X. And it by X date, something very straightforward, and then that would be drafted between them. And I would probably try to avoid at all points to actually draft the agreement, because one doesn't want to now become involved in you drafted that and lose your neutrality. And then they can take that to court if they need to make it an order of the court.
Yeah, I mean, and also what you can do as a mediator is to help them formulate sort of heads of agreement that they sign up to, but are not in the form of a contract, and they then go to a lawyer afterwards. And you might then, as a mediator, run alongside that until they've actually signed a document. But it also goes to preparation, and I'm sure all three of us will talk to parties about who needs to be at the mediation, and that then they should be legally represented, especially if a matter is on track for court. So lawyers are really a very important and essential part of the mediation. Okay, let's have a look now at some of the questions. And Sam and Hendrik, maybe I can just see what let's just go through them systematically, and either of you just indicate if you would be comfortable to answer that. So we've got one that says, what if the mediator picks up inequality between the parties? So a power imbalance, let's say, power in terms of either representation or understanding of the law or other resources. How does the mediator interfere with that power imbalance? And if so, how?
Okay. Yes, so I think it's usually a reality that in most disputes there is some kind of power imbalance between the parties. One party almost inevitably has more resources than the other, and parties have different varying strengths in kind of in the bargaining positions that they have. So that imbalance is not just a reality in mediation, it's the reality in litigation as well. Um, what is useful in mediation is that because the mediator is there to facilitate a negotiation, the mediator can play a much more effective role in making sure that that imbalance doesn't impact negatively on the negotiation process. The reality is that the mediator spends most of the time working with the parties in private sessions where the one party who doesn't have the team of three lawyers representing or advising in the mediation is not confronted with that. In fact, that team is sitting in another room and not glaring at them across the table. So that visible imbalance is after the joint session is almost done away with, and the mediator works with the parties in the private sessions and is able to give them equal amount of time and attention to put their needs and interests and positions to the mediator, and the mediator can facilitate a proper discussion. What one must understand, however, is that settlement agreements are usually determined by the bargaining power that each party have. If one party has more bargaining power than the other, that party is likely to get a better outcome than the other side. That is just commercial reality. And the mediator is not there to try and disturb that balance. The mediator is facilitating an outcome that is the best possible outcome that the two parties can get given their commercial realities.
Sam, any comment on that?
No, I think Hendrik's covered that, I think.
Yeah. Mediators are not, they're not going to come in and wave a magic wand and balance the power and achieve the fairest outcome. It's really, it's a negotiation, and it's down to the strengths and weaknesses of cases, the skills of the parties in their negotiation strategy, and very importantly, the risk that they might face if they don't settle. Perhaps linked to that, how, Sam, would you say you have those risk discussions with parties and their lawyers? The reality testing, the assessment of the worst alternative, that sort of thing.
I think someone asked a question, I missed the name. Someone asked a question about whether you can reality test without becoming evaluative. You use the lawyers in the room, which is why it's beneficial to have lawyers in the room, to ask them those quite difficult questions about the strengths of their case. You'll ask them about, they may raise, for example, I had recently a lawyer come with many presidents saying that, I'm sure about case, etc. And maybe the benefit is being able to ask them, okay, so how does this apply? And being able to take that information to the other side and saying, well, how would you address this in court? And whilst we're not here to try and come up with a decision, by being able to show either party the strengths and weaknesses of the case, reality testing allows the parties to see the weaknesses in the case and hopefully come to a solution. So it's a gentle process rather than a confrontational, you are wrong, for example, in relation to the law or something like that. It's very much letting the parties speak and understand their cases.
Yeah, right. And different mediators will take different approaches. Although the protocol talks about facilitative mediation, some mediators, especially if they are subject matter experts in that area, they might be asking questions like, if I think of employment, not that that would end up in the High Court, but you might ask specifically about procedural compliance because you know about that. And so the extent to which a mediator will challenge obviously will depend on the rapport between the parties and the mediator and whether it's appropriate, but also the knowledge of the mediator, and often those conversations happen with the lawyers. Tell me about how you're going to persuade a judge on this point, on that point.
Felicity. I think there was a question around the use of mediators that have specialist knowledge in the area of the dispute, which I think is relevant to what you've just said.
Yes.
If I could speak to that briefly, I, I think we all think it's good practice that the mediator must have an understanding of the principles and the law applicable to the area in which they're mediating. For instance, as to your example, if you're mediating a labor dispute, you need to understand as a mediator what the consequences are to the parties if there isn't a settlement, and what's going to happen next. Not because you're going to advise them on it, but because you're able to ask the right questions to get them to think about the consequences of not settling.
Yeah.
So to that extent, you don't need to be a true specialist, but you need to understand the area of practice within which you're mediating. And RAF mediations is another good example. You need to understand how the RAF scheme works, how delictual law works, and what the different components of dealing with a RAF dispute is. Again, not because you're going to advise the parties, but because you don't want to waste time for the parties to educate you on what needs to be done in terms to get to a settlement.
Yeah, absolutely. And conflict dynamics requires of all mediators who are going to be mediating RAF or medical negligence matters that they have specialist training in this area, which we offer from time to time. Just regarding, you use the point, educate the mediator. Now, somebody asked a question about parties sending briefs to the mediator beforehand. So how much work does a mediator do before the mediation to prepare and become educated on the dispute? And is that covered in the fee? Or is that an extra cost? How does that work? Hendrik, do you want to start?
Yeah, sure. Yeah. Yes. So let's start with what's covered in the fee. What's covered normally in the fee is that a mediator, the day fee includes 2 hours of preparation, 1 hour probably, which is going to be spent in pre-mediation meetings with the parties, and then another hour to go through the material that the parties would share with the mediator. Now, that probably already gives you an indication of the scope of the kind of preparation that mediators typically do. The mediator essentially just requires a high-level understanding of what the dispute is about, and a succinct summary of the points of dispute and the parties' positions on those points of dispute. That is typically enough for the mediator to get going on the day of the mediation. And if there's specific documentation that needs to be referenced, that inevitably can happen as part of the discussion on the day of the mediation. Having said that, there are some cases where it is important for the mediator to have a broader background, do more preparation, and that will usually become apparent during the pre-mediation meetings. And if that is the case, then the mediator will negotiate additional preparation time with the parties and then do that additional preparation.
Yeah. Sam, anything to add on that?
I must admit, I try not to give the parties any more work to do. So if there are papers already, for example, the pleadings, usually I'll say, well, that's enough, rather than sending the lawyers off to do more work, which generates more fees. So I'm reluctant to get them to do too much more work, unless there are no documents. And then, of course, it's helpful to have something. But yeah, that's my general position.
Yeah. Now, there have been a number of questions about how to encourage representatives, lawyers in particular, to see mediation as this opportunity we've been describing. It's turning the lawyer into what's often referred to as the mediation advocate, advocating for mediation as a dispute resolution process. So, what can you each say, maybe starting with you, Sam, on how do we talk to lawyers about mediation? What are the things you think, both of you are legal practitioners, what would be helpful for lawyers to understand and be able to do when they come to mediation? Because it's very different from representing a client in court.
I would say there's a different kind of strategy when one looks when one is preparing your client for a mediation. You're not looking at persuading the judge. You're not even looking at persuading the mediator. What you're looking at are really the strengths and weaknesses of your case. You're really looking at how to what you think would persuade the other side to come to your way of thinking, and where are some sort of ways, parts of the issues that you're happy to concede, perhaps, in order to get what you want. So more of a commercial discussion with the parties rather than a legal discussion. But it's important to know that the lawyers do have a role. It's not as if you can say, do away with the lawyer. You're needed for those serious discussions to discuss about the legal aspects and to discuss drafting the agreement at the end. So it's not as if, I think the lawyers often are wary because they're worried about them not being able to generate fees later on. But when one looks at the commercial aspect and especially when there are relationships that can be maintained, it's a very different discussion that one needs to have with the all parties when preparing to come to mediation.
Yeah, yeah. Hendrik?
Yeah, I think Samantha's has hit the nail on the head there. The attorneys and advocates that I've seen who are very effective in mediations are the ones who have kind of moved on from purely being a legal advisor to their clients to playing that role of being a strategic advisor and helping their clients understand and consider their broader commercial interests. I think most of us who've been involved in litigation understand that there are very few litigated cases that end up being beneficial to anybody involved in them, and those lawyers who understand that and who work with their clients to try and get to a commercial outcome that's most beneficial to them, they are the ones who are successful in the mediation and in the longer term who retain their clients, who build up loyalty with their clients because they're giving them value for money.
Yeah, yeah. And would it be fair to say that it's really about lawyers seeing their role not as gladiators for their party, but as really dispute resolvers or dispute advisors. So litigation is suitable in certain circumstances,
Yeah.
and certainly if negotiation or mediation fails,
Yeah.
but that there is a legitimate and helpful role for mediation.
Yeah. I do think there is a time when the lawyers need to be the gladiators. If all attempts had been made at getting to a settlement, well, then the battle lines are drawn, and that is what the lawyers need to be. I think it's important that before one resorts to that kind of final approach to the dispute, it's important that the lawyers do play that strategic advisory role and help their clients to make sensible commercial decisions.
Yeah, yeah, yeah. And then a last question from me, and that is about what happens in a mediation. There have been a couple of points about how the mediator handles confidential information or strategic information in the mediation. And one person made the point that they felt the mediator handled that exchange poorly and led to the other side becoming more entrenched. So, how does a mediator work with the parties in terms of deciding, helping the parties decide whether to take information across or not? And yeah, that coaching aspect. I think Kennedy made a point about the mediator being a coach, a negotiation coach. So, Samantha, how do you work with parties in terms of taking what they tell you next door in such a way that, to the other party, in such a way that it doesn't in any way prejudice them?
So I think the important thing is to make sure that it's what you take over is exactly what they have told you to take over. But before you take anything over, I always want to know, why do you want me to take that to the other side? So where does it take you? So for example, if they go and tell them X, Y, and Z, well, okay, but why would that help? And understanding the rationale behind it, and remembering that, of course, you are the process manager. You say, so you can say, well, maybe at this time, I'd like a permission not to take this over, and letting them being informed about what you do, as opposed to, in the case I think that we spoke about, where someone said, well, it just wasn't handed over until the last minute. Well, of course, someone is going to feel aggrieved about that because they thought the information was going to be shared earlier. So I think it's keeping the parties informed, knowing exactly why you want to take something from one side to the other, and letting them know that you are going to do that. That's how I deal with that.
Yeah, yeah. So media might ask for discretion as to whether they convey it at that point or not, and why, and yeah. Hendrik, any comment on those points?
Yeah, I think Felicity, those kinds of process decisions where the mediator decides when it's strategic to convey certain information, those are where good mediators are distinguished from ones that are maybe still learning. And I think, just as in the legal profession, not all mediators are equal. Some mediators are better at making better strategic decisions about when and how to convey information and offers, and they get better outcomes.
Yeah.
And I think the reality is that we're in a process where mediation volume is increasing, and the mediators who are good at doing this will get more briefs, and the mediators who are still learning hopefully will quickly get to a point where they are strategic and they get really good at doing this.
Yeah, yeah.
Mm.
Well, that really brings us to a close, and thank you so much, Hendrik and Sam, for your input and sort of candid sharing of what goes on in a mediation. And I think everybody can appreciate that we are real disciples of the mediation process, but we don't have the view that mediation is the silver bullet for every single case. Hendrik and Samantha still litigate and see a role for litigation and for arbitration. It's a question of when is mediation suitable, and we believe that it's suitable in a much wider range of cases than people sometimes believe, especially in the hands of an effective mediator. If you haven't already explored our website, you will find it here. I think Craig will put it into the chat, and you'll see that here, Rule 41A, mediations. There's information about mediations and our list of mediators with their profiles. For mediations that are not in terms of Rule 41A, you can have a look here at mediators. I hope my screen is still sharing the appropriate page. Our frequently asked questions are here, and many of the different guides. If you are looking for other resources like the agreement to mediate that we referred to, model agreements, our model agreements are here. And we look forward to seeing you either in mediator training or perhaps even in advocacy training. So the idea of mediation advocacy training for lawyers, what they need to know about mediation, and how to work strategically with your client in a mediation. So we thank you for joining us for this session, and would be very pleased to hear from you with any questions or concerns you might have. If there are any questions that we haven't yet answered, please feel free to be in touch. Otherwise, thank you very much for joining us, and look forward to seeing you in the training room or the mediation room. Thanks a lot.
Thank
Bye-bye.
you.
Thank you.
Bye-bye.
Bye-bye.